You are good. Now, Mr. Robinson is now in. So, good morning, everyone. I'm Magistrate Tidwell, and we are going on the record now. These proceedings are being held remotely and recorded pursuant to Indiana Supreme Court's emergency order issued on March 13th of 2020 and extended subsequently thereafter under Administrative Rules 14 and 17. We are here for a motion for emancipation filed by Howard Robinson, who appears in the virtual courtroom pro se. We also have attorney Aaron Hay, who represents Cynthia Robinson. And are there any preliminary matters that need to be addressed?
I would like to summarize where we are, if that would be helpful, Judge.
All right, thank you.
We are here on Mr. Robinson's motion to terminate child support as to the party's daughter. We agreed that the child graduated in July, as he alleges. However, we have a wage withholding order that is in effect, and there is an arrearage that withholding order is also paying off. So while we agree that the child is legally emancipated, the withholding order we're asking remain in effect, giving Mr. Robinson credit for the payments received in August, September, October, November, and to be received in December as credits against the arrearage that he owes, which would leave an arrearage of $13,578.72. In addition to that, Mr. Robinson was ordered to pay $750 of attorney fees incurred by Ms. Robinson that he did not respond to the motion for proceeding supplemental and did not answer interrogatories and did not appear for the hearing on April 20th, 21, even though he had service. And we're asking that that amount of attorney fees also be included in his arrearage and that there be an accounting at the end of his paying what we allege the balance to be due, including the attorney fees, to be $13,241.74. But we are agreeing that those amounts go toward the arrearage and the attorney fees, and that support will terminate August of 2021.
Mr. Robinson, do you have a response?
Magistrate Tidwell, thank you for holding this hearing. It's been a long time coming. My daughter will be 23 on March of next year in about 4 months, 3 months now. I'm here only for emancipation of Nia Robinson. I'm looking at the Indiana Code. I want to follow the Indiana Code. My Indiana Code says that termination of child support ceases when the child goes to college, when the child turns 19, and when the child finishes college, unless there's something else that needs to be done. Until we establish the date of her emancipation, because all of those dates, she's not lived with her parent since 2017. Now, this case file is probably one of the thickest case files according to the record. But I'm only here for the emancipation date. Upon the calculation of the emancipation date, then we'll find out whether or not there is any arrearage. I don't believe there's an arrearage at all, but I'm not here to discuss the math because that would be too complicated. I only want to follow Indiana Code 31-16-6-6. It says termination of child support obligations, exceptions, petition for educational needs, Well, my daughter didn't need any educational needs. She had a full ride to Northwestern and she finished in 4 years. It ceases when the child becomes 19 years of age unless one of the following conditions. Well, she's not at home. That's one of the conditions. That she was not emancipated before 19, but she should have been. The way I read this Indiana Code 31-16-6-6, it says that when she leaves home to go to college, I no longer pay child support. I pay educational expenses. But I'm here for the emancipation date only. I only want to talk about the date. Once that date is established, then the math will take care of itself because I got the math. It's been a garnishment. I've never missed a payment. Unless you're trying to say that the federal government missed a payment, then something is going totally wrong with this code.
Your Honor, we're not here to relitigate what the court has already ordered him to pay. He filed his petition alleging that she was emancipated as of July of 2021.
2017.
That date.
Magistrate Tidwell, let me say this again. I have been constantly filing order after order to get the court to follow Indiana Code 31-16-6-6 and establish the date that the child either turned 19, which was a few years back, might have you, when she went to college, which was 5 years ago, and when she finished college, which was about 5 months ago. No one has established a date. Without a date of emancipation from this court, you cannot calculate any math or any arrearage. If you look at the last order, they said until further notice, but nobody has decided to send me a notice. So I appreciate only to establish in this court hearing a date of emancipation, nothing else. If I can establish the date of the emancipation, the child support mathematic calculation will take care of itself.
You know, if he's through, I would remind the court that what he's arguing about her emancipation and education is not only being thoroughly litigated in this court, but also affirmed on appeal. The amount of the arrearage that he's paying off has also been established by the court. The portion of it that was going to child support ends, and the order would be to pay the arrearages that he owed. And that is why we want to continue to order, and we're asking that you add the $750 that he refuses to pay. As he said, he comes to court every year, and the judge ordered him to pay fees on the last hearing in the amount of $750. He ignores the court order to appear to adjust that fee, and he always addresses what he thinks he should have won on appeal, but he didn't. So that's our request.
Once again, dear magistrate, this is not about anything other than establishing the date. If we can follow the Indiana Code and establish the date that that child, Nia Parker Robinson, should have been emancipated, once that date is established, then the mathematics will take care of themselves. I got a court, Indiana, excuse me, sir, I'm speaking. Let me finish my thought, please.
Well, stop talking.
I have a record from the Indiana Support Enforcement Tracking System. There's never been a payment missed. There's actually been overpayments because the Office of Personnel Management in a letter to me said they can only process this retrospectively. In doing so, that information means that there is some credits that should be due, but they cannot be calculated without a establishment of a date that this child, the final child, the Indiana Code says she should have been emancipated at when she started school, when she turned 19, or when she finished school. My belief is that when she started school, we should have ended child support payments and reverted to educational payments, like we did the other first child, Imani Robinson in 2012. We also did Omari Robinson in 2016, but we have yet to establish any emancipation for the daughter that has not lived with her mother since 2017. And we are waiting on the court to decide that date only. None of the other issues are before the court.
Okay, Mr. Robinson, the court has made prior determinations that the child would not be emancipated in December of 2019. Again, your petition was denied in
At least a couple of times since then, Judge, he's filed the same report.
correct. I'm looking for it, and just give me a second. I believe you on the same issue were heard before Judge Dreyer, and that was denied. And so you refiled again on the same issues. Is that correct?
Ma'am, I have been trying to emancipate Nia since she went away to school. That is correct. Since she went to school, I've been trying to emancipate her and then deal with the educational support issues as identified in the Indiana Code, identify with them separately. They are not the same.
Robinson, this is the same issue. It has been litigated several times.
Wait, slow down, Judge. Let me. Would you answer what are we litigating? I'm not litigating anything. I'm only
You're asking to make the court to make a determination as to when she was emancipated.
when. Yes, ma'am.
2019, your request for emancipation for this child was denied. It was also denied in 2021, correct?
Ma'am, if you want to ask the truth, I only want the court to tell me what date will you emancipate her. I'm only asking for an emancipation date. Why am I not getting that response?
So you're getting ready to get an emancipation.
Okay, thank you.
But you keep bringing back up 2017 and times prior to that. And so I'm just making sure I'm understanding your position. And we're going to give you a date. Mr. Hay, what date did you calculate? Was it the date of filing of this petition for the emancipation? Or to relate?
The date he filed, and also looking at this unsigned petition, he puts the date of July of 2021. So we're not contesting his date.
You're what?
As far as
I'm sorry, Mr. Hay, you blanked out. What did you say?
we agree that she's emancipated as of July, for child support purposes and educational purposes as of July of 2021. However, Mr. Robinson has a substantial balance of unpaid child support, which is being paid right now by way of that wage assignment that he also objects to, which was entered over his objection. We're asking that that continue until such time as he's discharged the balance owed on the outstanding arrearage, and we're asking that you add the $750 that he was ordered to pay on his last petition, which raised the same issue, that he refuses to honor the court's order to come to court. We have that wage allowance going. We're asking that you add $750 to that balance. We propose that the balance owed, including that $750 on arrearages plus the $750, be $13,241.74. As soon as that amount is paid, we will agree to discharge the withholding order.
Excuse me again. With all due respect, that's not factual at all. The mathematical facts is this. The first emancipation of Imani, it took the court from
Judge,
February. This is not a litigation. This is not a litigation. It's a math. Please listen. This is a math calculation. The court took 8 months to issue the order, and by that 8 months, it was almost 8 months of accumulated overpayments. The same thing happened with Omari's emancipation, which is the second child. It took 8 months. This has not been argued in court. This is a math problem. I'm only trying to follow one thing. The Indiana Code reads like this. It says
Please don't
the
read
duty
that,
to
Judge.
support child with the exception of educational needs ceases when the child turns 19. That is all I'm asking.
Conditions, Mr. Robinson.
What condition?
And they were not met.
What condition, ma'am? Excuse me, Miss Magistrate.
I'm only here for the case before us, and you filed a petition. A verified
Emancipation.
petition
I just need, yeah.
alleging emancipation in July of this year. It was not signed. However, Mr. Hayes is not disputing that this child was emancipated in July 20 of this year. So I'm going to have Mr. Hayes prepare an order. You can also prepare a proposed order with findings of fact, if you so wish, and what you propose to be the resolution of this case, and have it submitted to me by end of business this week.
This week, Judge?
I'm sorry.
That's tomorrow.
Oh, is that tomorrow? I'm sorry.
That will be this week, yeah.
Oh, okay, today's Thursday. This week has been very long for me. Let's see. Is next Friday the 10th enough time?
Perfect. Perfect.
Are you asking this of me as well? Or are you asking that her judge continue,
Yes, sir. You're representing yourself, you can certainly tender to the court a proposed order of the proceedings.
what am I, wait a minute, let me make sure I understand, ma'am. I'm only here, I only proposed this petition, I came in person.
Date is July of 2021.
So you're saying that's when you're going to emancipate a full-grown child instead of the 19 that the Indiana Code say?
And this is the motion that I have. I'm not going back into something that was decided in 2019, 2017, or 2015. The motion before me was filed in July. I am emancipating the child as a matter of law as of July 2021. And by the way, your document was not signed.
I came in person and filed that with the clerk, and she told me everything appeared in order. I came physically to the court. It had to go all the way around.
You file a verified petition, you're swearing or affirming that the statements in there are true and accurate, and your signature belongs on there. Just for future reference.
Well,
Okay.
I'm really hoping to end this. When will we end? Excuse me a moment. When will we end the garnishment, please?
Once you've satisfied the arrearage amount, and I am going to award attorney's fees for defending this cause of $750. So the arrearage amount plus the $750 attorney fees will be $13,241.74.
Now, can you tell me how you calculated that, please? Because I don't have an arrearage calculation at all.
That's why you this is tentative. This is tentative. If you have documentation to show that it should be offset, then I will certainly consider that before I make a decision. But Mr. Haight is requesting $13,241.74. Take away $750 for the attorney's fees, that would be your arrearage amount. So do the math on
Okay,
that.
tell me what arrearage is calculating, please. Is that a support arrearage or is that an educational arrearage?
It is the court's order in existence through today.
Ma'am, I'm just asking you, do you know what the difference is? Because I have constantly paid and nobody seems to segregate these costs. There are two separate issues according to your codes. There's educational expenses and there's child support. And I don't know which one is which. This number was not given to me in any of the previous cases, what the arrearage was, because I could have made arrangements
That's not true.
to try to pay.
We have presented arrearages
When you come
in
to
order
court,
to
you
get
have a
the
duty
court
to
order.
have gone to the clerk's office and gotten a printout.
I have it.
And you can calculate from the time the order was, and from the time in which the order was made until The child is emancipated. That's how much you owe.
When I send this, do I address it to Attorney Ryan? Judge Ryan Gardner, or yourself, the
No,
court?
You will send it to T-O, T is in Tom, O, M is in man, M is in man, I, E is in Edward, dot, E is in Edward, P is in Paul, P is in Paul, S is in Sam, at indy.gov.
Let me read the first letters for you. I think it's Tommy spelled with an I-E, T-O-M-M-I-E dot EPS at
Correct.
indy.gov, so I can send that electronically.
Yes, sir. In Word format.
Yes, ma'am, I'll use Word.
It's mine to go to the same address.
Yes.
That's EPPF, right?
EPPS is in Sam.
Oh, S is in Sam.
Yes.
EPPS. Got it.
All right. Thank you, gentlemen.
Thank you, Yoder.
Thank you.